Mr. Backman, could you please place your appearance on the record?
Certainly, Your Honor. Zach Backlund on behalf of Richard Roberson, who is the defendant in this matter and is appearing by Zoom with us today.
And Ms. Roberson, I see your name. Are you present and can you hear me?
Yes, I am. And yes, I am.
All right, thank you. And Mr. Backlund, this is your objection to a child support?
Yes, Your Honor. That's correct. Yep. The objection was. Sorry, I keep interrupting. My audio is cutting in and out, I think, so I apologize. So the objection is that the calculation was done, and after speaking with Mr. Roberson, it doesn't seem that the income from Ms. Roberson's second job at the Buckboard Bar and Grill was included in that calculation. So if that is where Ms. Roberson is continuing to hold a second job, we'd ask that that income also be included in the child support calculation.
All right, thank you. Ms. Roberson, are you working a second job?
I am not, Your Honor. I've never been employed at Buckboard Bar and Grill. It's a family, well, it's not family owned, it's family friends own it, but I've never worked there. All
right. And Mr. Backlund, if there's any questions you'd like to ask, Ms. Roberson, go ahead.
Sure. Thank you, Your Honor. Ms. Roberson, can you hear me okay?
Yes.
Okay. And where are you currently employed?
Aetna, a CVS health company.
Okay. And what do you do for Aetna?
I'm a claims benefit specialist.
Okay. And is that a full-time position?
It is. I work 7 to 3 every day. 7 a.m. to 3 Friday.
Monday through Friday. Okay. And are you paid a salary or are you paid by the hour for that work?
Hourly.
Okay. And what is your hourly rate?
$17.50.
Okay. So it'd be $17.50 times 40 hours per week. Is that correct?
Correct. Okay.
And have you utilized any additional sources of income?
I have not.
Okay. When are you leaving the minor child with a parent during your parenting time?
I am not.
Okay. Have you done that in the past?
In the past, I have left the children with my mother. I did a couple volunteer shifts for the brewery, but I've never worked at Buckboard, and I have never maintained a steady stream of income from any other job.
Okay. Can you describe the work that you did at the brewery?
They had a Oktoberfest, so I went in there and assisted them with Oktoberfest. They just needed an extra hand, but there was no income that came from it. It was more of like a free food kind of thing that you got.
So, and when you say the brewery, is that the Big Buckboard Bar and Grill, or is that something else?
Big Buck is a restaurant in Gaylord. Buckboard is a bar that I've never worked at in Reed City, and the Reed City Brewing Company is an entirely separate place in Reed City.
That's what I do not. What is the name of the place? Is that the brewery in Reed City?
Reed City Brewing Company. I have not been in the Reed City Brewing Company since October.
And you simply volunteered your time? You weren't paid?
Correct.
Did you receive any sort of tips or other consideration?
No.
Okay. I have no other questions for Mr. Roberson, Your Honor.
All right, thank you. Did you want to call your client as a witness, or do you have any additional evidence you'd like to provide?
I would like to call Mr. Roberson. It looks like he might be getting interrupted at the moment. Okay. Okay. And is it your knowledge and belief that Miss Roberson was working a second position?
Yes.
And in that position, was it your understanding she was earning a second stream of income?
Yes.
How did you come to believe that Miss Roberson was earning a second stream of income?
Well, I initially learned from it from my children, and then the plaintiff's mother, Betsy Davis, had informed me that she was working, as well as covering Betsy's shifts as well.
So let me clarify. So Betsy is the children's maternal grandmother?
Yes, it is.
And when you say covering shifts, so where does Betsy work?
From my understanding, it was also at Buckboard.
So the Buckboard Bar and Grill. And so Betsy informed you that Miss Roberson was covering her shifts at the Buckboard Bar and Grill?
She didn't state the Buckboard, but that's from my knowledge, that's where she was employed at.
Okay. And what did she do there for work?
Bartender, server.
Okay. Do you have any idea what the pay structure is there? Is it tips plus wages? Is it wages, or what is
I
it?
have no knowledge of that.
Okay. Do you have any other information regarding her employment beyond the statements that the children and your mother-in-law provided to you?
No, I do not.
Okay. Do you have any idea how many days Ms. Robertson was working, filling in shifts?
I knew it was at least on Fridays and maybe a day or two during the weekdays.
Okay. Do you believe that was every Friday?
It was, I believe it was every Friday for at least 2 months.
Okay. But do you have any knowledge about income that would have been earned at that position beyond knowing she was working?
No, I do not.
Okay. All right. I have no other questions for Mr. Robertson, Your Honor.
All right, thank you. Mr. Beckman, anything else you'd like to say regarding this matter?
Nothing else, Your Honor.
Your Honor,
Well,
if I have an opportunity.
well, ma'am, I'll certainly give you that right. I'm prepared to make a decision based on what I've heard, but if you'd like to say some additional statements, go ahead, ma'am.
Mr. Robertson does have rental income that he has not put on record. He has since, after sending in the objection, moved in his parents and is receiving rental income from him to pay his mortgage.
So ma'am, I can only deal with what was filed for today, so I can't address those issues. If you want to address those, you have to file a separate motion.
Okay, sounds good.
All right, so based on what I've heard, I don't believe there's enough to establish that Mr. Robertson did have an additional source of income. Mr. Robertson did not have direct knowledge of that. He indicated he was told that through, it sounds like his mother-in-law as well as his children. So that would be hearsay, and Ms. Robertson has denied that she received any income from doing that. So based on that information, I am going to deny the objection. Any questions, Mr. Backman?
No questions, Your Honor. Thank you.
Thank you. Ms. Robertson, do you have any questions?
No, Your Honor.
All right, thank you both for appearing. That does conclude the matter, and you may all sign off. Thank you.
Thank you.
All right, front of the court, what is the status of this matter?
The defendant has a support obligation of $140 and a balance of $2,638.20. The defendant called yesterday and made a payment over the phone in the amount of $250. That's still pending. The defendant has other support obligations, so it is unknown how this payment will disperse. In October, the defendant had contact with a request on how to remove a show cause hearing that was set for that month. He made the requested payment of $150 to remove the hearing.
Thank you.
Yes, Your Honor.
All right, what would you like to say regarding this matter, sir?
I got really behind. It's been quite a hard winter for me, even prior to winter. My other cases that I have for child support, one, I'm supposed to get child support paid to me for my twins, and I had just within the last month got custody of my other son. So all my money now should just be strictly going to the case with Jessica up in Otsego County.
All right, well, what I'm willing to do is adjourn this matter to see how that payment gets processed and how you are doing with any additional payments. So I will actually adjourn this to March so we can see what happens with that payment, as well as to make sure you're making a February payment. I will adjourn your matter to March 13th, and we'll check back in then to see where we're at.
Will I get something in the mail for like court times, I'd imagine?
Yes, we'll send you a notice of that hearing.
Okay.
All right, thank you.
Thank you.
Thank you. We have both parties present. Front of the court, what's the status of this matter?
This hearing was adjourned from December 20th, 2023 to allow the parties if a credit should be applied to the defendant's account and for the court to address remaining account balance. Friend of the court has not received any information. The defendant has a support obligation of $569 and an account balance of $35,534.86.
Thank you. Ms. Bannock, can you hear me okay?
Yes.
And ma'am, we were here in December. There was some discussion about credits. Is there anything that you'd like to say regarding that matter, since it does not appear that friend of the court was notified of anything?
Yes. So Ms. Brower looked up the information of how much he's paid me altogether in the last, it's been 2022. That's outside of the court. It came out to $7,300 and something dollars. And I know some of it was for, like when I brought the kids to visit him, but I can't say exactly how much it was. So you could just credit him the $7,400, and I don't want to go outside of the courts anymore.
All right, so ma'am, you're indicating that you are voluntarily giving him a credit of $7,400, or do you want to have a hearing on that issue?
No, that's fine. I'll voluntarily do it.
All right. Mr. Bauer, can you hear me okay?
Yes, Your Honor.
All right, you've heard Ms. Bennett say that she would agree to a $7,400 credit. Are you seeking a larger credit than that, or are you in agreement with that?
That $7,400 credit would be towards all of the money that I sent to her with Apple Cash. There were some other credits that I would like to be applied from prior to that. I'm awaiting bank records from SunTrust Bank here in Florida. Also, there were some other credits. The total of what I have to date is $8,626.46. I do have a spreadsheet with everything written out that I could email or mail to you guys. I did also get something from you guys in the mail saying that I had to return some paperwork back by November 23rd. And I have the postmark on the envelope. It was not postmarked until December 26th. So I'd like the court to know that I was unable to do that because I didn't receive it before that date.
All right. When was the last time you made a payment on this matter?
Let's see here. 12/19 of 2023, I paid $300 to Tasha directly with Apple Cash.
And it sounds like she does not want direct payments anymore. So what is your plan moving forward with payments, sir?
I'll pay you guys. So then there's a better accounting of it.
All right. So you feel the credits that you are requesting, how old are those? They include last year or not?
They go back to 2022, and there are some before then. I'm still awaiting the accounting from my bank. They're only able to give me like 1 month at a time.
All right. Well, I don't think I'm inclined to go that far back and have a hearing if there's not an agreement as to that amount. Obviously, there was a court order in place for payments.
Okay. The court.
They were not direct payments. It sounds as if she has stipulated to a certain amount, $7,400.
May I speak, Your Honor?
Yes.
Okay, this goes way back to the beginning of the case where the court order was put in place. I was actually incarcerated in Crawford County, and I was not able to even attend any hearings, so I was unable to have any say in this matter. So I'd like to go back to the beginning if the court would hear me there.
Well, you would have had to say if you filed a motion or, certainly avenues you could have taken 2024 in today's hearing.
Okay, I was never notified of any court dates whatsoever, so I don't have a law degree. I don't know how to do all that.
All right, well, what I'm going to do here today is, given the amount that the plaintiff agrees to, I will grant a credit of $7,400. And ma'am, it's correct that you do not wish to have any direct pay anymore, correct?
Correct.
All right. So moving forward, that should not be the avenue to pay it. If you pay it direct, you may not get a credit. We are, though, going to set the matter for a hearing in a couple months to make sure that payments are being made, because you would have obviously the January payment's not come due yet, but let's adjourn this matter to March 20th just to see where we're at with that January and February payment.
Okay, is there a way to have a review on the case for support amounts and custody and visitation?
There are ways to file those motions. You can speak with the caseworker or contact an attorney.
Okay, excellent. Thank you, Your Honor.
Thank you. All right, thank you both for appearing. That does conclude this matter.
Thank you.
All right. I don't believe we have Ms. Totten present. In front of the court, what is the status of this matter?
The defendant has a support obligation of $258 and a balance of $1,906.43. The last payment was received in December 2023 in the amount of $220 and $138.69 in October. The defendant reported a new employer on December 14th, but no payments have been received from that. The friend of the court would request to adjourn to March 20th to monitor payments.
All right, so is it correct that you have some new employment?
Yes, I started at KLC here in Gaylord, Michigan.
Have you had any paychecks from them yet?
I only got 2 so far. My first one was literally only 6 hours worth of pay, so I couldn't make a payment. And then my second one, I had to pay rent, so I gave my mama in hand rather than go to court because I was only able to pay so much. I wasn't able to make the full payment to front of the court.
All right. Any reason why you can't make your January payment before the month's over?
I can as soon as I get my next check, which is on the 18th.
All right. So what we are going to do then is adjourn this matter to March 20th, just to make sure you get that January payment and that February payment done. If those payments are in, the friend of the court may just cancel this matter if they think that is appropriate for March 20th. So if you've made those payments, you might not have to be back here, but make sure you're getting those payments in. Okay.
Yes, sir.
All right. Thank you. You're all set.
All right. Thank you. Have a good day.
All right. I've heard from nobody. It appears that neither party is
I'm here.
present.
I'm here. I'm here,
All
Your
right.
Honor.
All right. I saw your mouth moving, so I didn't know if you were talking to me or someone else, but now you're unmuted. So you have Mr. Perkins present. Friend of the court, what is the status of this matter?
The defendant has a monthly support obligation of $431 and a current balance on the account of $1,686.23. Last payment received was in December of 2023 in the amount of $294.11. He does have a income withholding that has been taking effect, so we would like to adjourn to March 13th to monitor that those payments are going through. And if they continue to come through and meeting the obligation, then we wouldn't have any need to have that hearing.
Thank you. Mr. Perkins.
I'm sorry, Your Honor. I missed the first part of the call. I didn't know if I was on deck or not.
All right. So it is indicated that you have a new income withholding order put into place. Is that correct?
Yeah, I was between jobs, Your Honor, and had a lapse of income for about a month.
Okay. Well, given
yes, I do have,
statements,
but everything's in place.
all right. Given the statements from front of the court, we are going to adjourn this matter to March 13th just to monitor that with income withholding order. As indicated, if all the payments are being made, you may not have to appear that day. Okay.
So, Your Honor, can I ask a question?
Sure.
Can we just? I think whatever the balance is, whatever she said, the amount that was missed, can we just spread that out over the next 7 months? Because the child age is out 7 to 8 months. Can we just spread it out?
Well, you're always you're always able to pay the additional amount to get this matter wrapped up. So if you want to add that on, that certainly can be done.
Can they just do it automatic through the friend of the court, just as an overage to make sure she gets paid?
Back to?
Yeah, we can collect more.
All right.
More per month.
So you have no
for
objection.
the next 7 months. No, I want to make sure she gets paid.
Collecting more on the amount that's owed and try and spread it out over 7 months. Is that correct, sir?
No, go for it, please.
All right. So on the request of Mr. Perkins, what we can do then is add on to the monthly amount, the amount that would be needed from to pay the arrears off within 7 months. Okay.
Yeah.
All right. Thank you, sir.
Yeah. Thank you. Bye-bye.
You're all set.
Good morning, Your Honor. I'm here. This is Danielle Woodard.
Thank you. I see Mr. Spreeman present, but you need to unmute, sir. All right. Well, Mr. Spreeman, are you?
I am, Your Honor. I am. Yes.
Thank you. All right. For the court, what is the status of this matter?
The defendant has a monthly obligation of $407. The current balance is $10,395.19. The defendant previously appeared before Your Honor on September 20th of 2023, and it was recommended that he be found in contempt of court unless a $3,000 payment was made. That payment was made on October 5th, 2023. Since then, 2 payments have been received. $100 on December 21st of 2023, and $70.25 received on January 3rd, 2024. The front of the court seeks direction from the court on how to proceed today.
All right, so it sounds like you made a payment back in October to address a contempt matter, and then you've only made a couple payments totaling about $170 since then. Is that correct?
Yes, Your Honor.
All right, what's your plan here to make some payments, sir?
I just gained employment last week through Straight Sides Construction. We're building pole barns all winter. I get my first check next week, and the payments are going to keep going. I'll try to make a payment by Friday, but my first check won't be till next week. But I could probably make it pretty small.
And are you working full-time for that job, sir?
Full-time.
Ms. Woodard, do you have any questions or any comments that you would like to make?
The only comment I'd like to make is that I'd like to see payments actually start coming in, not just measly small payments. I don't think it's a grand amount that should be paid in, and I think it is definitely something that Nicholas could do if he actually put some real effort in.
Let me see my kid.
Mr. Freeman, prior to this job, when did you last work?
When?
What was your last job? Yes.
I was a tow truck driver for Otsego Lake Services.
All right, when did that stop?
Last year. Yeah, last year. I'm in January or April. I don't remember.
All right, well, you did a good job in paying that contempt amount, but now we've fallen behind again. I'm going to give you a chance with the new job to get your payments in for January and February and see where you're at. I'm certainly expecting those to be full monthly payments. And you also need to start addressing the back amount, which is very large, but we'll come back here March 20th to make sure those payments have been made and then to see where we're at moving forward. Do you have any questions, sir?
No.
And Ms. Woodard, do you have any questions?
No, Your Honor.
All right. Thank you both for appearing. That does with matter. You may sign off.
Here, Your Honor.
Thank you. You do have Mr. Tackett present. In front of the court, what is the status of this matter?
The defendant has a monthly support obligation of $914. Current balance on the account is $3,532.72. Last payment received was in October of 2023 in the amount of $144.28. We are seeking guidance from Your Honor to see what we should do next.
All right. Is it correct that your last payment was in October for about $144?
Yes, sir. I had a direct, payment coming out of checks. I have been unemployed from the end of August until the end of November, and automatic payments have not recurred again. I would like to state that I can make payment, and I will be making payments going forward. I have to apply the new information for my new company so that those payments can be made. This is the first time I've ever been late at all, except for right when our divorce went through, because they counted back 7 months. All of those arrears have been taken care of, and I'd like to go forward paying that way.
So the job you have now is different than the last job you had?
Yes, sir.
All right. And for the court, do you have the information for his employer?
Not the current employer.
All right. Who is your current employer, sir?
Current employer is CBIZ Network Solutions.
And where are they out of?
They are out of Creve Coeur, Missouri.
For the court, do you have his contact information if you need to call him to discuss?
Actually, if you could verify that, we would appreciate
All right.
that.
We have your phone number, sir?
664.
All right. So you may hear from the caseworker to get some additional information to get this income withholding order established. We will adjourn your case to March 20th just to make sure that that's put into place. If it is in place and payments are being done, then that hearing can be canceled. But until that is put into place, so you may have a pay period or two where that's not in place, you are expected to make payments. You understand, sir?
Yes, Your Honor.
All right, thank you. All right, you're all set. You can sign off in the morning, sir. Friend of the court, what is the status of this matter?
The defendant has a support obligation of $558, an account balance of $8,971.39. The last payments received were $49.45 in December of 2023, $116.40 in November of 2023. So the friend of the court would ask that a monthly pass-through support obligation of $50 be ordered, bringing the monthly payment to $608 until the arrears are paid in full.
All right, do you agree that it's accurate that you're about getting close to $9,000 behind and your last payments were $116 in November and about $49 in December? Does that sound accurate?
I think so, Your Honor. I was working for 360 and they were taking the money out of my checks, but I ended up getting laid off.
All right. Are you collecting unemployment?
No, I'm not. I was going to, but they didn't give me my paperwork and stuff in time to be able to do any of that. And like I was on them about it, but I don't know, they just didn't give it to me in time. I explained the situation.
When were you laid off, sir?
They ended up saying I was laid off October 23rd.
And what's your plan then for
I've called
income?
the friend of the court. I've been looking for work. I've been kind of helping my buddy doing the drywall stuff, but it's like a hit or miss. Like I've just been trying to get the word out there to get more work, but like so far it's just, I don't know, I made a little bit to be able to cover rent and try to get a vehicle, just see the kids and like I tried to get a hold of a friend of the court also and let them know that I got laid off and everything like that too. And I tried to explain to him about the whole child support thing with my daughter too, to see if I can get it lowered, because even Maya, she even told you guys that I wasn't her father and that she was going after the real dad for child support too. And so I tried
those are issues that have to be dealt with through separate motions. So I mean, we're kind of getting off track here. I guess I'm confused. So the job you're laid off from, are you going back to work for them?
Yeah, when they'd open back up.
When's that?
After the snow melts. It's a landscaping company.
Have you worked for them previously, or was last year your first year?
Last year was my first year working for them.
And was it your understanding you were going to get laid off and collect $0 throughout that entire layoff?
No, I was gonna try to collect unemployment for the layoff, but they ended up not giving me the paperwork in time to be able to do that. So I've been scrambling around trying to find jobs.
All right. Is there anything that prevents you from working?
Right now, I don't have a vehicle. My vehicle ended up breaking down, and I ended up putting money into it, and it broke down even more. And like I had money to give her again for December, but she asked me to do Christmas for the kids because she couldn't. So, and that's all I had. So I ended up using that to buy the kids Christmas presents instead of and I don't know.
Any physical issues that prevent you from working?
No, sir.
All right. Anything else you'd like to say?
No, sir.
Well, I mean, my concern here is you just seem to be falling farther and farther behind now then. You said you've been laid off since October. Have not found any new employment, don't have any income coming in except for sounds like some smaller odd jobs. But there's
yes,
nothing.
I planned on
So, I mean, the effort doesn't seem to be there. I understand you may have purchased some Christmas presents. Unfortunately, we don't have Miss Spikeford here to say, hey, give them a credit because you purchased those.
Yeah,
I'm going to adjourn the case to I'm just going to adjourn it about a month to February 21st to see what effort you're making here to get some payments.
Okay. Is there any way I can try to get it lowered?
There are ways to file motions to seek that, sir. Yes, you could speak to an attorney or get the forms from front of the court. So we're going to adjourn your case to February 21st. But I will indicate that if you do make a payment of $1,200 prior to that date, you would not have to appear that day.
Okay. I did get a hold of the friend of the court, and I've asked them about it a few times because I was trying not to get in, like, to be in this situation. Like, I've been trying for real. I know it don't seem like it on paper, but I have been. And like for my situation to be able to see the kids, like I'm the only one that goes and gets them. She don't make an effort to try to bring them to me or nothing. So I got to try to make sure I got a vehicle going. And
we are all set for today. We'll see you back here February 21st, unless you make that payment. Okay.
Yes, I can.
All right. Thank you.
And Jack's iPhone, I assume that's going to be you, Mr. Kremkow. If you could unmute.
Yes, sir.
All right, we're here today, sir, on your objection to a child support recommendation. Is that correct?
Yes.
All right. Ms. Foreman, did you see his objection?
Yes, I did.
All right. So let's kind of go through this line by line, I guess. So it first said that the overnights is not correct. Is that correct, Mr. Kremko? You're objecting to that?
Yeah.
The overnights?
Yes, my objection to the overnights is correct. We live in the same house, so I don't understand how I was accounted for 0 overnights if we reside in the same house.
Well, if you reside in the same house, why are we doing support? What's the situation, Ms. Foreman?
Jack has been living. I offered him a temporary place to stay in August of 2022 after he was evicted from another home. And he has been living rent-free in my house since August of 2022. We are not together. So I'm seeking child support for our daughter.
And ma'am, I mean, how do you guys handle parenting time and
I have her. Oops, sorry. She's with me. He works all week. He's gone during the week, and he's home or here on the weekends. Typically every other weekend he's around when his son is here. Other than that, she is with me.
All right. Do you think he should have credit for some overnights?
He has not done any of the overnight responsibilities. She is in my physical care. So no.
Mr. Kremkow, what's your position on that?
We've had our own child support set up for the past however many years, where I pay her monthly. I do pay her monthly. I wasn't evicted, but I did move out from my previous residence, and she did offer me a place.
Hold on, sir. So we're getting off base of my questions. We don't have a ton of time. You're asking for some credit for overnight parenting time. She's indicating that you really don't have overnight. So what do you want to say on that issue?
I don't see how, right, when she said that I don't take care of the overnight responsibility, I mean, she's pretty independent, so I don't see how really anyone could justify saying that they do take care of
Is it correct that you are gone during the week?
For the most part, I mean, I could be there at night, yes, but I am gone during the week. I am there Friday, Saturday, Sunday.
Right. She sort of made it indicate like you kind of have sort of an every other weekend where you're a little more responsible for the duties. Is that accurate or not accurate?
Not so accurate.
All right. Well, what do you think's not accurate about that?
I'm there. Just because
she's there too. So the difficulty is she's there. Hold on. So difficulty is she's there too because you guys are choosing to live in the same house. I mean, how do you handle parenting time? How do you feel you handle parenting time? Do you take your daughter off and do things? Do you?
Yes.
Okay. And you have another child, is that correct?
That is correct, yes.
What's your parenting time with that child?
Week on, week off during the summer, and then during school, every other weekend.
Okay. Does that child come stay with you at that residence, or do you go somewhere else?
Yes. No, we stay there.
All right. Then, sir, you'd also written that childcare expenses is false.
Well, in the recommendation, it was noted that I did not submit my information, and in talking with Edward from the front of the court, I think there was some kind of an issue with his email or something. He did actually get my information and entered everything incorrectly and all that. So the calculation, I feel, was based off of not correct information, as well as the amount of over $1,000. I feel is pretty, that's really, really steep. Financially, that would really ruin myself.
Are you paying rent or not paying rent?
Paying rent, yes. We don't have a contract or anything.
There was an expense on here for childcare. Do you feel does not have a cost for childcare?
Yeah, she is after school, when she gets off the bus, she is with her grandmother, which is her mom, and her mom isn't charging her childcare. Other times that Charlotte may need childcare, it's her dad, as well as my mom watches our daughter. So there is no childcare.
All right.
So it was recorded that there was a weekly or monthly childcare cost, and there isn't one.
All right. Front of the court, is it correct that initially you did not get the financial information for Mr. Krumkow, but have that now?
That is correct. We received it after the objection was filed.
All right. And do you have any information regarding childcare expenses?
Yeah, it looks like the cost for childcare came from the childcare provider. So that's all that we looked into it. It was determined that there was an annual childcare amount of $1,950.
All right. Ms. Foreman, what would you like to say about the childcare expenses?
Charlotte does go to Latchkey a few days a week. During the fall, she goes 4 to 5 days a week because my mom's not available to get her off the bus. And during the summer, she goes to daycare 1 day a week. She is with my parents the other days, so I do not pay for those days, but she does go to daycare 1 day a week during the summer, or if there's another day that grandparents aren't available.
Is that the information then that you submitted for that calculation?
Yes, sir.
Submitted? Okay. Well, I do want to make sure we get Mr. Krumkow's income correct. I mean, obviously he was given an opportunity. There was some hiccups in the process, but that information is now received. So I do think a new recommendation should be prepared based on that financial information. I will deny the objection as to the child care expense. But for overnights, I think he should be given some overnights on a every other weekend basis. So we should add those into the calculation also. So what's going to happen is the court's going to prepare a new child support recommendation, send it out to both of you. You'll both again will have a right to object if you have any disagreements with that document. Any questions, Ms. Foreman?
No, sir.
All right, and Mr. Krumkow, do you have any questions?
No.
All right, thank you both for appearing. That does conclude the matter. You may sign up. And Mr. Winkleman, can you hear me okay, sir?
Yes, sir.
All right. So this is a motion regarding support filed by Ms. Burke. And Ms. Burke, you are seeking some reimbursement for healthcare expenses. Is that correct?
Yes, sir.
All right. And Mr. Winkleman, did you receive her motion, and do you have any objection?
I received the motion, and yes, I have an objection of yeah, I was never asked about this, never anything. I was just told this is what I was paying. My daughter's 12 years old and she sucks her thumb still, so there was, you know, I wish I'd have been asked, because I thought that, you know, she should quit sucking her thumb before she gets braces, because it's kind of pointless to get braces. And so that's where I stand at that, I guess. I would like the court to relook at the you know, the child support. Also, I only take home $300 a week from my job. I have the children one night less a month, and Nicole Burke hasn't really supplied the court system with honest income on her end. So
okay, so if you want to seek that request, you do have to file a motion. There are specific rules you got to follow in filing a motion if you're looking for a change in the support calculation. So today we can only address her motion. I don't have your full file, so I'm not sure. Do the two of you share joint legal custody, or does one of you have the sole legal custody?
I have the sole legal custody.
Okay. And ma'am, what would you like to say regarding your motion regarding support in this matter?
Well, braces have been on the list for a couple years now, but like Jamie stated, she does still suck her thumb. However, the orthodontist had offered to put braces on the back of her front teeth to stop that, which tomorrow she has those put on.
So are you getting the braces on the recommendation then from the orthodontist?
I am.
Okay. And do you know what your total amount to pay is going to be?
I have already paid $6,020.
Okay. And that will cover the full expense then, as far as you know, barring any other issues?
Yes, sir.
And it looks like, based on the support calculation, that, thank you, that the Mr. Winkleman is to pay 59% of any uninsured healthcare expenses?
Yes.
Friend of the court, have you done any calculations on this one?
Yes, Your Honor. So the first thing that we did was, with understanding that the $6,020 is the total, we subtract the ordinary medical amount for 3 children for 2023 from that amount. So it was $6,020 minus $1,362, which left $4,658. And then you multiply that by the 59%, which left the remainder of $2,748.22.
All right, Ms. Burke, did you hear that calculation?
I did.
All right, do you have any objection to that calculation?
I do not.
All right, Mr. Winkleman, any other objections that you wish to make, sir?
I just don't feel that it shouldn't, even though the orthodontist said that, I mean, I know I'm not a doctor or anything like that, but I just don't feel that it's the time for it. And you know, I carry insurance on the children, and somehow they get state insurance also. So it's, I don't know. It's all a little bit confusing. And like you said, I need to go back for other stuff. So I just
do you agree that, sorry, go ahead.
I just don't feel it's the right time for braces. My son Levi was supposed to go to an orthodontist a long time ago. He never has. I don't know. Anyways, I don't feel it's the time, and I don't feel she needed him at this time. And to be told that's what I'm doing, not asked, I just don't really feel that I should be covering this end of it. I pay child support for 1 night a month, like I said. And
you agree that Ms. Burke has the legal custody?
Well, yeah, that was changed somehow in the past. I should definitely file to change that. So yeah. Definitely.
Right.
We have the same parenting time as we always did. For some reason, it was changed to that with the hearings that we went through before.
Okay, thank you, sir. All right, so based on the testimony from the parties, which primarily includes Ms. Burke indicating that the orthodontist did recommend braces, that they are making some changes, it appears, based on the child's habits, but that it was recommended. I don't find that is an unjust decision that made by Ms. Burke to proceed forward with that. So given the calculation, which includes addressing the annual ordinary medical and then the percentage, I would indicate then that Mr. Winkleman would owe that, make sure I get it right here, $2,748.22.
Correct.
Okay. And then as for collection,
I'm not sure if we can add it onto the monthly amount or if it just gets added as an arrearage, but we could, either way we proceed, we can send a letter out to let them know.
All right. All right, so Mr. Winkleman, I am going to grant the request for support, and then we use that calculation, which reduces the annual ordinary medical amount, which has to be paid, which is already paid, and so that comes out. And then we times that by the percentage in the support order. So I am ordering that you pay that amount for the braces. The parties do have a right to object to my recommendation. You'll have 21 days to file that objection. That information will be provided in the paperwork that is sent to you. Do you have any questions, Ms. Burke?
I do not.
All right. And Mr. Winkleman, do you have any questions, sir?
Oh, yes, I just appreciate it if this paperwork would be sent to my home for some reason, or to my address. It was sent to Elliott Blumberg last time, and I didn't even get this stuff until almost January 1st. So,
okay. What is the address you'd like the court to use?
My address is 29.
All right. And Mr. Blumberg is not representing you anymore then?
Well, not at the moment, no.
All right. Thank you. All right. You both are all set and may sign off. And I was present. Can you hear me okay, sir?
Yes, sir.
All right. And Miss Brandow, can you hear me okay?
Yes.
And I want to make sure I'm getting your right last name. Is it Brandow or is it Kapanki?
Kapanki.
Okay. The two of you are married though, correct?
Yes, sir.
All right. All right. So we're here today on a initial hearing regarding custody, parenting time, and support. Mr. Brandow, what is your position on those issues?
Honestly, I was filing for divorce, and I must have did that. I mean, I have my daughter right now. She's incarcerated. I don't want to keep her from her or none of that. She was a great mom. I'm not saying nothing like that. So, I mean, when she gets out 50-50 is good with me. I mean.
Okay. Ms. Kapanki, when are you scheduled to be released?
26. 2026.
2026. Okay.
Yeah.
Now, do the two of you have one child together or two children?
One.
We have one, but obviously legally two.
Well, that's my concern, because when you're getting divorced, you got to address what's going on. Who has custody of that child now?
I have custody of both of them.
Well,
my parents have power of attorney of both my children also on my behalf.
All right. Well, I want to talk about it's Abel. Is that the other child, correct?
Yes.
All right. So where does Abel stay right now?
With my parents.
All right. So, Mr. Brandow, I see that at one point, it looked like you contested paternity of that child, but didn't really file any paperwork. Is that correct?
I did get a paternity test, and I did send it into 46th District Court, and I've never heard nothing back from that. The child support got dropped because I did have a child support bench warrant, and I went in there and paid some money on it, and I forget the guy's name that had me go and get a DNA test, but we paid for it. Christina paid half, I paid the other half, and it came back not my child. And I sent it into the mailbox at 46th District Court.
All right, so you just sent in the report saying you're not the child, didn't file any motions or do anything like that?
No, Your Honor.
All right. So in that case, so there's a case regarding Abel back from 2018 when it was filed. There was a default judgment in 2019, and it says the court finds that, Christina's the mother, you're the father. It did say that defendant asserts he is not the biological father. Defendant must file appropriate motions under the Revocation of Paternity Act to further challenge the motion. And it sounds like what you did was then send in that report, but did not file anything else. Is that correct?
Yes, sir.
So, I mean, I think legally you're still considered the father. There are ways then through this divorce case to address that issue too appropriately and get that resolved, but you're going to have to do that if you're ever going to want to get this divorce closed out completely.
Okay.
I mean, I think where we're at right now is you've got, so as far as the other child, what's the other child's name?
Amani.
Yep.
All right. So as far as Amani does Amani reside with you full time at this time?
Yeah, she's with me, and then I let her go to her, which is Christina's mom. So I let her go to her house for a couple of days so she can spend time with her brother.
Okay. So I mean, given Ms. Kapanki's current status, I think it would be appropriate that Mr. Brandow have at this point, the primary physical custody. What about legal custody? The two of you want to have joint legal custody at this time?
That's fine with me. I mean, if she's cool with that.
Yes.
Okay. Joint legal custody relates to the big major decisions as far as big major medical decisions and or school decisions and that type of thing. So what we can indicate then is that the parties would agree to joint legal custody, Mr. Brandow to have the physical custody. And then obviously when the time comes for Ms. Kopenki to be released, the two of you can submit a new agreement or file a motion. But Mr. Brandow, you are going to want to either do some research on your own or speak to an attorney about how to address the other child in this matter. And make sure that, you know, if you already got that, hopefully you still have those results from the paternity test, or maybe it's in the circuit court file, but with that, you should be able to get it done, but there are certain steps that you have to go through.
Okay, I will do that immediately.
And sir, is it correct that in this matter, you're asking that the court grant you the parties joint legal custody and that you have the primary physical custody? Is that correct?
Yes, Your Honor.
And you feel that's in the best interest of the children of the child at this time?
Yes.
And obviously, given Ms. Kopenki's incarceration, there would not be any child support in this matter. And ma'am, do you also agree to share joint legal custody and Mr. Brandow to have the primary physical custody?
Yes.
And you believe that's in the best interest of the child?
Yes.
Friend of the court, questions on this matter?
No, Your Honor.
All right. All right. Thank you both for appearing. That does conclude this matter. Thank you.
Thank you. Thank you.
Ms. Davis, can you hear me okay? I do need you to unmute. Okay.
Yeah.
Thank you. And Mr. Dress, if you could unmute, let me know if you can hear me okay.
Yep, I can hear you okay, Your Honor.
Thank you. So this matter is before the court following an ex parte motion that was filed by Mr. Dress that was denied by the judge, but then referred to friend of the court. My understanding is there may also be another matter proceeding, a neglect and abuse case that has been opened and is in the court system. Is that correct?
Yes, Your Honor.
All right. Is there an order in that case regarding custody right now?
Right now, it's just supervised visitations for myself.
Okay. So, Mr. Dress, this is your motion. Are you seeking anything additional through this court, or given the neglect and abuse case, are you not seeking anything additional through this court at this time?
As of this time, Your Honor, I was seeking the full physical custody as written in the paperwork. My information that was given to me, I only have physical custody through foster care proceedings. As I learned in the proceedings and the system and how everything works there, Your Honor, I was informed that in the other proceedings in the juvenile, things can be granted as well, if I'm correct.
Okay. All right. Well, I only asked because I just didn't know if you still were seeking an evidentiary hearing in this matter. I represented Ms. Davis, I don't know, I guess it was 10 years or so ago on this case. So I had to disqualify myself because of that prior representation. So this matter then would be sent to the judge, Judge Mertz, to handle any further hearings on this issue. Do you have any questions regarding that, Mr. Druffs?
No, I do not, Your Honor.
All right. Ms. Davis, do you have any questions?
Yes, I do, sir. Will I be getting legal representation through the courts?
No, there's not court-appointed counsel for custody matters, only when you're facing some type of jail or penalty like that.
Okay, so then I would need to secure an attorney before that court date?
Yes.
Okay.
If you want an attorney, obviously you don't have to have one, but you have that option. I don't know if you qualify for legal services, Northern Michigan Legal Services, but you could check with them.
Okay.
But that's not through the court itself, but they do have some ability for some representation.
Okay.
All right. So I'm going to indicate that due to my prior representation of Ms. Davis on this matter, I am disqualified. It is Court Rule 2.003, parentheses C1D. So this matter then will be referred to Judge Mertz for any future scheduled hearings. Okay.
Thank you, Your Honor.
All right, thank you both for appearing.